A very good evening to all the members who have enrolled for this session. Myself, CA Rekha Umarship, Regional Council Member, SIRC. I take immense pleasure in inviting you all for this session on Competition Act. So, to tell about this session, we have been organizing sessions on FEMA, tax, audit, corporate laws, GST. So, to be very frank, this is one topic which has not gone for rounds of discussion. So, but if you ask me about the prominence of this particular topic, this is one of the topic, say, especially for a country like India, we need to have a level playing ground, and this particular Competition Act has actually made complete use of that. And this is because of this particular act, we have a healthy competition or a commercial competition in India has been put into place. Now, if you see, especially once this particular act came into picture, we had a prohibition on all the monopolies or on the restrictive trade agreements. So whatever was the anti-competition or whatever was the practices that was being followed by the companies in India, there was a level playing ground, as I told you. So especially if you see, whenever there's the electronic gadgets came, say around 10 to 20 years back, we had vendors who were charging exorbitant prices. Now, because of the advent of these kind of laws, we have a level playing ground, we have prices which are kept as low as possible at the same time without compromising on the quality. Basically, it was giving a very healthy competition to the business or the entrepreneurs, and the consumers were getting benefited. Now, today I take immense pleasure once again to invite the faculty for the day. We have Vanita Pattnaik ma'am. So to tell about her profile, I think I should be telling various things because she is an assistant professor with NUJS, and she has been having a teaching experience of more than almost 2 decades. Almost 2 decades she has been into the teaching field. And basically her subjects of specialization include corporate insolvency, insurance, mergers and acquisitions, international investment laws, commercial instruments and laws of banking. Now, before actually going into her academic life, because it is very quite interesting how she has progressed herself from a student to actually a facilitator now what she is. She has an extensive experience in corporate training areas like RTI, POSH, contract drafting, economic offenses, as well as employment laws and cyber laws, mediation and conciliation. And she has also been responsible for taking a lot of training within India as well as outside abroad, especially University of Hamburg. And she is also one of the principal persons who have been designing the courses and training programs for various institutions, say Durgapur Power Plant, West Bengal Power Plant, and even Vivekananda State Police Officers Academy. And she has also been a resource person for the IIM Calcutta, Symbiosis Hyderabad, XLRI, NIFT, Pondicherry University, and so now one to tell about her academic span. I would say she was the first Indian student to study at the International Tribunal for Law of Seas for uses and protection of seas, legal, economical, and from the natural sciences perspective. And she also has full scholarship during those times, and even she did her master's in law as well as a business management from the Vicarious Law School, which was again with full scholarship. I have to again mention that. And she also did her research scholarship from the University of Dundee. So I think it is really exciting to invite you to this particular forum, ma'am. The session is all yours.
Thank you, Rekha. Thank you so much. It's really kind introduction you have given. Just a small thing that I would like to say. Right now, my designation is associate professor. It is not assistant professor. They finally decided to bump me up. So today's topic. Can I start, or do we have to wait or something? We can start. So today's topic, because I knew I was coming to chartered accountants, the group of chartered accountants, I have divided into 2 parts. One part is absolute theoretical and one part is compliance, which is what you people are best at. So what I will do is I will just first tell the compliance and then the theory. The reason why I have turned it on its head is primarily because if I start with the theory, I know that people would zoom out, and compliance somehow rings a bell with all of you. So I'll start with the compliance part so that you can just connected when I do the theory part. And as Rekha, you rightly said, when the very essence of competition law is to create a fair market for the consumer. It is to ensure that the business community is duty bound to provide alternative choices to the customer. So whenever there is no alternative choice to the customer, whenever there is only one dominant company or a business, in such a situation, they would have to abide by certain regulations, certain compliances. If not, they would have to be answerable to the Competition Commission. So that is the basis of it. And if you see the preamble, so I'm just starting this slide. So if you see the preamble of it, this is the preamble of it. It simply says that it is an act. One second, is my screen visible?
No, ma'am.
It's not?
Yeah, no, it is not visible, ma'am.
Oh, ma'am, you need to click show my screen button again, right below the orange arrow.
One second.
Or else I'll take back the rights and give you back. You should be able to click on that.
One second. I'm just doing it. Okay. Is it now visible?
Visible, ma'am. Visible. Please continue. You can put it in slideshow mode and then you can continue.
Yeah, there is a slight difficulty. If I'm putting on the slideshow mode, I think it's coming something like this.
Okay, no problem, ma'am.
Because
There is option of display setting, right? There is option to duplicate the slideshow. Right top on. No, top right. So top left. Sorry, display setting. Display setting. You can see there is option called duplicate slideshow.
Yeah, now
duplicate,
it's better.
Yeah. Now it's
Okay.
full stream mode. Yeah.
So as I was saying, this is the preamble of the act. If you see this, the act has been brought about with a view primarily to prevent the practices which have an adverse effect on competition. That's the main theme. That's the main underlying theme throughout the act and its application of it. It also has the aim to promote and sustain competition in different markets as in vertical, horizontal, and that type, not just economy, but geographical markets as well as your vertical markets as well as your horizontal markets. The whole idea of it is to protect the interest of the consumers. In protecting the interest of the consumers, it also by default ensures that there is enough freedom in between traders to carry on trade, maybe here, maybe in a different market, but they would necessarily have to have some form of ecosystem wherein they would be able to progress with the trade and do their own business. So this is the preamble that is given, and as I said that I will do the theory part numbers here. So when we understand or when we say anti-competitive agreements or abuse of dominant position, it is simply we are meaning to say about behavior of companies wherein they would not want any other company to provide and competition to them. So they would go out of their way to ensure that either by undercutting of the prices or building up such high walls or having an exclusionary market. But different strategies, if they create an anti-competitive climate in any particular geographical region, that would be anti-competitive, or where they would have similar price. So you would have, doesn't matter which company you would buy. Like for example, the cement. If you buy the cement, you will find different companies having the same rates. So those are anti-competitive behavior, and if it is put down on pen and paper, then it would become an agreement. When does this dominant position gets abused? When the company or the behavior of the company ensures that there is no other player who would be able to thrive or provide an alternate business opportunity to the market, then it would be an absolute abuse of dominant position. So this abuse of dominant position has been taken very, very strictly by the Competition Commission. They come down very harshly upon it. So there have been some benefits of that, and there has been some interesting positions because of that. I'll be coming to it if the time permits later on in the presentation. So how do you have a compliance with this? So as I had said, if you see the previous slide, your anti-competitive agreements are under Section 3 and your abuse is under Section 4. So how do you comply with Section 3, which is your anti-competitive? So when we speak of anti-competitive, here, as I was saying, how do you define or how do you identify something as anti-competitive? So anti-competitive, there is no peg mark or balance where you can just put it and say, yes, now it is anti-competitive, now it is not. So in order to do that, the Competition Commission came up with this element, that is your appreciable adverse effect. Now, what is appreciable adverse effect on the competition? Which means it's not just it has to be absolutely prohibitive or absolutely anti-competitive. It also means that when you're having an impact, a negative impact on the business that is being provided, or the options that is being provided to the consumers, that itself will be a hallmark or a benchmark of anti-competitive agreement. As I had mentioned, when you have lateral agreements, they are called horizontal agreements, or when you have vertical agreements, that is the supply chain, all of that, both of it is covered under. So whenever you are having complete monopoly of any one area and you are the only provider, you have to ensure that while you are providing, it does not become adversely or abuse of the dominant position. So if there is an agreement, the business says that you can be in a dominant position, there is no restriction on being on a dominant position. You can have your business highly successful. That's also more than welcome. But you cannot have an agreement with another competitor in order to have a negative impact on the market. Now let's take the example of telecom market. If we see the scenario pre and post entry of Jio. So Jio was one of the market shakers. So it was a disruptor. It still is a disruptor, but at its entry point, it was a major disruptor of the market. So many of us would recall the high data prices that we had to pay, the high call or the message prices that we had to pay for if we had a SIM with either Airtel or Vodafone. So the only alternate was BSNL. So this major disruptor comes in and then the prices starts crashing to the extent that it is now truly affordable throughout every section and category of the public. So how come it is not being labeled as abuse of dominant position, having an anti-competitive agreement, or having an appreciable adverse effect? The element that you have to keep in mind is, one, it did not prevent anyone to carry on with the business. Two, it did not have any agreement with other companies to fix the prices. As a disruptor, it provided a market, a possibility to the public, to the consumer. As a service provider, it provided certain services which could be met with the other companies, may not be met with the other companies, but there was nothing wrong with the services being provided. So they provided the services, or free services, if you can call them, though I have always maintained there is nothing free in this world. The point is, the whole reason why they provided and how they provided was to make for themselves a position in the market, to make their name visible in the market, which they succeeded. And because of their unique business model and concept that they had, they have become one of the forerunners in the market. So even with all those disruptive practices, they do not come under your anti-competitive agreements, primarily because they did not conduct any such behavior which could be identified as anti-competitive agreements. Now, what is the next compliance? The next compliance is having any kind of arrangements, be it in respect of prices, or be it in respect of quantities, or be it in respect of services, would be anti-competitive in nature, which means if I'm even discussing with the employees of another competitor, in such a situation, that would amount to, if proved, of course, that we are having an anti-competitive agreement. So agreement doesn't have to be necessarily in black and white on paper. It can be oral. It can be tacit understanding as well that can be put down to anti-competitive agreement. So any enterprise, while conducting its business, should not discuss, should not enter into any agreement, should not have any joint action with any competitor on any matters, be it of price, be it of supply of products or produces, or be it for supply of services. So there is this blanket ban, a prohibition on any of these. So traditionally also the business houses would always have commercially sensitive information that they would try and protect. And yet there can be situations where there could be an attempt of one business wanting to buy out the other business, and they would have to do their own diligence. Even when they're doing their own diligence, they will have to be super careful in order not to disclose any information that they discover during the process of the due diligence, be it commercially sensitive, be it sales figures, be it manufacturing figures, which are not publicly available. So this prohibition is a very, very general subjective prohibition which can apply to any circumstances wherein a company will have to essentially prove that it has not entered into either a tacit or a proper arrangement and agreement with its competitors. Now, continuing with your section 3.3 is essentially wherein it speaks about who can enter into or indulge. So this is more like your horizontal, that is enterprises and other enterprises. So it can be persons, association of persons, it can be person and enterprise, it can be any practice being carried on, it can be any decision by any unions, trade unions, or business houses that they would have, or any sort of association, however loosely you want to tie it in. So if they are having similar identical business, or if they are having same type of business, and there is price rigging, if there is discussion on the market strategy, if there is discussion on the manufacturing strategy, let's say, for example, I'm a suitcase manufacturer, and then I say, well, I'm going to produce this year only 10 suitcases. Now this I can make a public knowledge, and my competitor says, okay, fine, then I make 5 suitcases. So in such a situation, even without having any tacit understanding or agreement, we are trying to ensure that the market responds to us in the best manner possible. But the same thing, if we had the discussion over a cup of tea and then decided to fix the figures, then it would be coming squarely under your section 3, subclause 3. So going back to the example of your telecom operators, so the pricing or the plan or the design of the different voice calls and the data plans that they come up with from time to time, many times they give bundled offers. Right now, I don't think we can even find an offer which is just solely voice call options. Even with prepaid, you will always find them bundled with data. So the whole idea of it is, while the pricings are different, you will not find a similar plan with more than one company. So you can say that, okay, for 99, this company provides this, for this one, this provides that. But you will not find the same things being provided that they say that, okay, we provide plans only for 99 or for 999. So essentially what happens is, you cannot have an understanding to fix either the pricing or the supply or the services. So if you're fixing anything, be it tacitly, be it explicitly, that will squarely fall under your section 3 subclause 3. So I was talking to you about the appreciable adverse effect. Now, what is this appreciable adverse effect? I have mentioned that in the past, and I'll just explain it a little bit more. How do you identify it? This can be identified by few markers. First and foremost marker will be when the determination of sale prices. When the impact of the business is such that it has a direct outcome on the sale prices or on the purchase prices, or it has an impact on the control of production or the supplies of the products, the markets, the technical development, the investment. So any one of these areas, if it has impact, that is an adverse impact, that would be ticked as your adverse effect, appreciable adverse effect. So whenever there such effect has an impact on the consumers, that would always be immediately reflected in the shares of the market, in the production that is available in the market, or the services that is available in the market. And you can take any sample size and you can say, okay, fine, this is the market that we are going to study. So given that when you have a particular market where you have a very clear indicator of this appreciable adverse effect, you can be sure that it always almost results in your bid rigging or collusive bidding. So more than once auctions bids have been set aside by the courts, primarily because of the bid rigging, primarily because of the smell of collusive bidding. But that is more to do with the laws of tender and the your general financial rules, not so much with your AAEC, primarily because AAEC is just a play in between the regulator and the complainant. So if the consumer or another company goes there and complains, they have to essentially prove that there is some impact. And once there's an impact, then the commission starts giving out the notices and starts its own investigation. Now, what are the things that a company will have to avoid? A company will have to stringently avoid any form of arrangement, however loose it may be, or however implicit it may be, with regard to production, with regard to development, with regard to services, with regard to distribution, marketing, or any such thing, or even sharing of your customers' data or market. So many times we do on and off receive calls from different finance companies offering us loans, or we get calls from its admission time. So there could quite be possibility you will getting calls from different coaching institutions, from different colleges, that okay, this is what we are having and we would be giving you this offer. Now, how do they get this data? Now, this data they generally would buy off from the market, or that is what they would claim, that yes, we have bought it from the market. But such mass mailing or mass calling services are strictly prohibited, which essentially means while it does not get traced back which company has sold off the data, it has a telling impact on the market or on the data that is compromised in the market. So whenever a company has some form of arrangement wherein it shares or sells such data, that is absolutely prohibited under the Competition Act. So in no circumstances should a company be even seen as selling the data, because selling of the data can hugely compromise a business, or rather I should say purchase of data would hugely compromise businesses. So there have been institutions, companies, business houses which had to pay very stiff penalty just to regularize their data, because they never got it from the verified source. They could not explain their sources, and because of which the government comes down pretty heavily on them, and they would end up paying. To give you an example, let's say I've purchased data for 40,000, and just because it was not a rightful purchase, I might have to end up paying a penalty something around 6, 7, 8, 10 lakhs. So it depends upon how you deal with the data, or how do you purchase the data, and how do you validate it. So a company should typically avoid such such arrangements in order not to fall under your section 3. So I had mentioned about diligence. Now, due diligence is something that every business does from time to time, particularly when it wants to take over. This diligence is almost always outsourced off to either accountancy firms or to law firms, or to both, depending upon the type of diligence. Now, whenever there is a diligence exercise, how to best go about it? The best way to go about it is by building up Chinese walls, which means the people who are involved in the diligence work should have necessarily signed the non-disclosure agreements. They should keep the information that they discover absolutely confidential. They should not be permitted to discuss it either within or outside the company too. So whenever there is a diligence exercise being conducted on a competitor, ideally it should be by an outsourced party. But where it is not, where the legal department has to do it, or where some other members of the company do it, in such a situation they would have to keep these Chinese walls very, very strongly. So while doing diligence, besides the non-disclosure agreements, what is required? What is required is the transfer of your commercial, confidential commercial secrets, or your commercial interest, or the data that you would have, that is absolutely should not be discussed or disclosed. So exchange or transfer of planning documents, or details of projects, or plans, or any business ideas which might lead to furtherance of business, or which might be labeled as commercially sensitive data, will have to be done in a manner that it does not react back or boomerang back on the company, saying that, well, this is absolutely prohibited. So any policies that the company would have which is not publicly available should not be discussed, should not be exchanged, and should not be, even if it is exchanged, should not be let out in the public that you would have access to it. Now, what happens if you do not comply? Of course, there is penalty. I mean, it's a commercial thing. So in commercial laws, you will find that the penalties are always almost monetary. Very rarely they are punitive. So when you are having monetary penalties, so essentially it is they're of a nature that it should be of such high or such steep nature that it would itself be a deterrent. So almost always you would find that such penal provisions or such monetary penal provisions are steep. They are on a per day basis. So it is similar with your Competition Act as well. So whenever there are consequences, or whenever there is an action by the CCI, that is the Competition Commission of India, for non-compliance, then what happens is they initiate an inquiry. Upon initiation of inquiry, if they find that yes, there is an element of AAEC, or abuse of dominance, or bid rigging, or any other element that falls under the forbidden territory, then they would give a penalty. Besides the penalty, they would also give a cease and desist notice. Many a times where they find that since India, we have primarily what we have is family-owned enterprise business as a business form, rather than, even though they might be registered as company, unlike what we understand a company in the Western world. In India, when we say company, it's essentially family-owned enterprises. So many a times this individual liability is always taken up, and it's applied in a very, very heavy manner. So individual liability is applied. Because of that, you would have a reputational risk that arises in the market, and any company that has faced any flack because of such negative collusive behavior would also get entitled, which means, let me explain this a little bit more. So let's say company A and company B are indulging in a collusive behavior, and I have company C. And because of this behavior, I have faced certain losses, or my losses are more like the business profits that I could have done, but I never did. So on my complaint, the CCI can take it up and essentially compensate me, take the money from the parties involved and compensate me for my loss or the damage that I would have so-called faced. So these are the consequences of non-compliance. Now, what happens when there is an inquiry? So as I said, the first point is inquiry. So without inquiry, CCI will absolutely never take any step, just like that. So whenever there is an inquiry initiated, there will always start with a notice or a summons. Now, even though it's civil in nature, non-compliance would invariably end up in adding to the financial burden. So if you receive a notice, if you receive a summons, the best way is to ensure that you are present. So not only that enables or it proves that you are complying with the directions of CCI, it also proves that you have the real intention of setting whatever you have done wrong. If it is proved wrong, that your intentions are in the right place. So here we make a little bit of jump from section 3 to 43, but that's only because I wanted to bring forward the various penalties that they have put. So whenever there is a inquiry, whenever there is an investigation, if you fail to turn up, if you fail to respond, ideally it is preferred that the company turns up on its own and not just sends lawyers, but they do send lawyers, and that is also acceptable. So if there is a failure of turning up, then the fine could be of 1 lakh rupees per day. There is a cap of, I think, 10 lakhs, maximum 10 lakhs that can be applied. So it can be applied on the company, it can be applied on the person if the notice is by name. Similarly, if there is falsification of data, if there is misreporting or misrepresentation of data, or destruction of data or destruction of document, then it can be up to 1 crore. So the same punishment, the same punitive, the financial penalty can go up to 1 crore a day. Once you have the summons, then starts the search and seizure. Now, search and seizure here, they fall back upon the CRPC, because search and seizure is the right only that is provided under the criminal law. None of the commercial laws have elements of search and seizure, though they do have vested it from the CRPC to conduct it. So the moment you are talking about CRPC, you are talking about the criminal court system. So essentially, whenever there's a search and seizure conducted, they would have to conduct it as per the CRPC provisions, which means you will have to have the proper panchanama, you'll have to have a seizure list, you will have to have a search team, you'll have to have witnesses, civilian witnesses who would certify that these are the elements that you're removing from the from such and such location. So what can they take in their custody? So not just anything that comes into their hand, but they can literally choose what to take and what to leave behind. So it can be books, documents, papers, laptops, mobiles, servers, anything that they feel is important enough in the process of investigation. Every type of gadget, however minor it might look like, they have a right of confiscating that. In addition to it, individual wise as well, this search can extend to individuals or the KMPs that we speak of in companies, or the directors that we speak of in company. So the search team will do an absolute sweep of everything, starting from the electronic records to the non-electronic ones. So this search and seizure is essentially, they're looking for is any type of tacit understanding that the company would have entered into. So in between the search and seizure and the final order, many times they give interim orders to have a reprieve on the company that they're taking action on. So once an interim order is there, the terrible knee-jerk reaction is not to comply with it, or the other part of the horizon is absolute compliance. Absolute compliance is good. Non-compliance will again attract the same thing, 1 lakh per day. And that is for each day of such period of non-compliance. And this can go up to 10 crores. So a maximum of 10 crores can be applied for such non-compliance. Now CCI has something very, very interesting called a lesser penalty program, or it's essentially the person who rats out the collusive behavior first gets off with almost 100% of penalty. So a lesser penalty is where a group or a member or an individual who steps forward to Competition Commission and provides an absolute information along with evidences, of course. So you cannot simply say that, okay, fine, this is what they're doing. You will have to provide some evidences of it. So in such a situation, you're given that person, that company is given absolute immunity. That means they will get 100% waiver from the penalty. They would get a free run from the penalty. Sometimes they also do get a little bit of punishment, but as a first mover advantage, they definitely have a benefit under the lesser penalty program. This was introduced primarily to give an incentive to the business who would want to step forward and rat out essentially on the cartel or on the collusive behavior of other people. Now, how do you avail this? In order to avail this, CCI demands few things. First and foremost, it says that you have to give us absolute disclosure. That means you cannot participate from the day you come and disclose. So you'll have to show us clear proof that you are not participating in that behavior. You have to give proper evidence for violations of collusive behavior or anti-competitive agreements. You, if possible, documentary evidence is far more preferred over any other form of evidence. But even telephone conversations, messages on WhatsApp, any other any form of communication, let's say, for example, Facebook. So even that is taken as a form of communication. So, but the most preferred is the documentary evidence. So once all of this is provided, then it demands absolute cooperation. Cooperation is a very, very generous kind word that is being used. What it means is you have to cooperate with the CCI at every step of the proceedings. You have to be available at the drop of a hat for any of their summons. You cannot be seen to participate in any concealment or destruction or manipulation or removal of any documents which may not lead to the establishment of cartel, but if you are seen to be doing it, then you will not get the benefit of lesser penalty. Now, this determination of lesser penalty will decide when the applicant comes forward. Is it already under investigation and then an applicant comes forward? Then the penalty is different. If there is nothing and there is just fresh off, an applicant comes, knocks on the door and says, well, I've got information and documents. If the search and seizure is complete, that evidence has been evaluated, placed and proved, do they come in at that point of time just to ensure that they do not get heavily penalized? Finally, last but not the least, the type of evidence that they provide. Is it a clinching evidence, or is it just something that is supplementary, that is persuasive in value? So this quality of documentation or quality of information that is provided, all of these elements go long way towards determination whether you get a 100% off or just 10% off on the penalty. So what they are looking for is vital information, documentary evidence, or evidence that has a clear proof of there is cartelization or anti-competitive behavior. When any company steps up, much before even any action has been initiated, if there is no notice, no summons, no action, then you can be sure that such company would invariably have a benefit of having a complete waiver of the penalty. So the lesser penalty scheme functions as an incentive scheme, but in order to utilize the incentive scheme, you have to be the first mover right at the beginning. So if you're seen interim in the while the proceedings are going on, if the summons have gone and then you realize summons have gone and then you go and say, okay, fine, I need to disclose, then the lesser penalty will have a different percentage. If the search and seizure has been conducted already, evidence has been collected, but not evaluated, in such a situation, there will be a different percentage. Where the evidence has got evaluated, then it is of a difference. Now, what is evaluation of evidence? Evaluation of evidence is where there is the investigation is near complete, and the investigation, through the investigation, the CCI proves that these documents that are placed as evidence have evidentiary value. That is called evaluation of evidence. So all of these elements are very, very critical to determination of where the company stands in this lesser penalty scheme. So we have notice, summons, then you have search and seizure, then you have evaluation of evidence, and then you have sanctions. So whenever there are sanctions or penalties that are applied, if there is proof of antitrust behavior, if there is no proof, then section 26 will apply, and they would get a notice that everything is good and fine and you can carry on your business. But when 27 gets applied, then the first thing that they'll give is an order of cease and desist. That means you are hereby here and forward forbidden from carrying out the business in the form that you have been carrying out. Second, they'll give the order for penalty. Third, they will give the order for modification of the agreement or the contracts that the company would have, to the extent that the commission feels that it should or should not. And fourth will be they'll give a slew of directions that it expects that the company would essentially abide by for with regard to, be it payment of penalties, be it for payment of compensation, be it adherence to certain rules or laws. So all these are in a series of orders that comes out from Competition Commission. So far yet they have not on their website put in the details on how the process works, or if you can take a informal guidance note like you can do with SEBI. They don't yet have the system, but I'm quite confident sometime they will bring it around. Now this compliance, now this is the same thing that we are talking about, the compliance of post and antitrust sanctions. So when you are talking about post and antitrust sanctions, you have to have the enterprise and its officers complying with it. So whenever there is a penalty to be recovered, in such a situation, they have a particular rule for it, this manner of recovery of monetary penalty regulations. So a demand notice goes in the prescribed format, and a recovery officer is entrusted with such recovery, and from both the enterprise in general and its officers in particular, or individuals in particular. Okay. Now, when there is even that there is not non-compliance, it may sometimes happen that because of the situation that was created in this investigation, or because the business folding up, or because the company just doesn't feel like paying up, there can be a situation where there is non-compliance. So whenever there is non-compliance, there are certain additional measures that your CCI decides to take. So be it with regard to non-compliance of orders, or non-payment of penalties, or not turning up when the summons are given. For each one of these things, what they have is they usually will go in for financial punitive action rather than criminal action. But yet they do have an element that if required, they can file a criminal complaint at the CMM, New Delhi, wherein you have an imprisonment charge of maximum 3 years or 25 crores as fine, or both. but generally more often than not, it is 1 lakh rupees a day per day for the period of non-compliance. That's capped at 10 crore. So if you really don't have to follow, you'll have to ensure that you cross the 10 crore. Then comes the compensation, recovery of compensation. This is very different from recovery of penalty. Penalty is the punishment. Compensation is what is given to the third party or the complainant. So this compensation for loss or for the damage suffered because of such non-compliance by the company of the orders and directions will have to be also done by the recovery officer. So all of this again is in between 1 lakh at a minimum and 10 crore at a maximum. Only and only when it gets into the CMM court, then it becomes 3 years imprisonment and 25 crores. Now combination. So this is something that all of you deal with very, very closely. That is your mergers, acquisitions, and amalgamations. So when we speak about combination of any nature, be it a compromise arrangement, merger, acquisition, amalgamation, so essentially any transaction which would trigger or touch upon a trigger of the CCI. So essentially, whenever more than one company combines and the turnover thresholds that is prescribed under your Section 5 of your Competition Act is of such a nature that they find that because of the turnover, they are not able to take the benefit of any available exemptions, which means they will have to mandatorily file an application for permission before the CCI. So this is why we say that the Competition Commission's combination part is mandatory notification. So if you're able to avail the exemptions provided, then you would not have to notify, you would not have to make an application. But if you are not able to take benefit of the exemptions, it essentially means you have no choice but mandatorily file for notification that you are undertaking this merger, or you're undertaking this acquisition, or you're undertaking this amalgamation. At the same time, it is also a suspensionary one. What does it mean? It means that if you're not being able to do this under your Section 6, you will not be able to do this. So whatever you cannot do through the front door, you cannot do through the back door, which essentially means that if you cannot do business without permission of CCI, you cannot continue with the process by any other means. So you cannot share data, you cannot carry on the work as everything is fine, and ensure that the merger process is going to be complete at some point of time. So essentially what it means, if this transaction is under the notification of CCI, it cannot be consummated, it cannot be completed in whole or in part before the clearance comes. So when will this clearance come? It can be either implicit, that means 210 days passes, there is no action, so you're free to go ahead. If 210 days have not passed, if there is notice, then you're free to go ahead. But if 210 days has not passed and there is no notification, you cannot simply go ahead. You have to wait for that 210 days to pass by. So from the date of filing the notice, the countdown starts. When does it stop? So from the first day, if you start counting, if the Competition Commission gives a communication that you require XYZ information, or they require XYZ information, the countdown freezes, and then again when you provide the information, the countdown starts. So the 210 days period is like the period other than the period that is required for the communication in between the enterprise and the CCI. So this is what it means when we say it's a suspensionary one. That means the business of merger cannot go through in any form, be it part, be it full, be it just by the way, let's complete the processes or let's complete the paperwork. You cannot do it. You have to wait. Now, what are these combinations that we're talking about? It can be of many, many varieties. it can be acquisition of control, it can be acquisition of shares, it can be acquisition of voting rights, or essentially anything in this category that falls under SAST, all of it would fall under it. So assets, all of it would come. At the same time, when you have a direct or indirect control and you're acquiring that, and that acquired, the company where it is targeted is a business that you want to acquire in such a situation also, that is seen as a combination that requires a permission or an exemption. So all of these will come under the different categories of combinations or the law which governs combinations. Then we have something called the Anti-Circumvention Rule or the de minimis rule. Now, what is the de minimis rule? So essentially, what it says is whenever there is such transfer of assets in a merger, in an amalgamation, in a takeover, the value of the assets for that time period will be calculated or will be attributed to that of the transferee company. So it will no longer be assessed separately, but it will be assessed along with the company that is taking over. So this is what it says about the anti-circumvention. So you cannot utilize your merger in order to keep your asset and your valuation of assets separate. So your regulation 59 of the combination regulations, which clearly mentions that whenever the assets are being transferred to the target enterprise, in such a situation, the transferee enterprise will always have the valuation of the assets. Now let's talk about compliance framework a bit. Now, compliance framework is essentially a framework that every company should have for itself, just to ensure it is an active risk management system. What is a compliance framework? This is a very, very commonsensical, very pragmatically developed framework which is given by the CCI, which companies do not use or apply, but ideally if they have in place, it makes their own life simpler. So just like you have a CSR committee, audit committee, a compliance committee or competition compliance committee is something that has been pushed as an agenda since I think 2017. And so far it has not taken off. And this entails what is the work of this compliance committee? It essentially has the job of evaluating all the agreements. It has the job of evaluating the market conduct and any schemes that the company would have. It would also have a situation where there would be an active, rigorous compliance system. So some form of standard operating procedure would be in place. There would also be some training programs for the employees and the senior management towards ensuring that there is a good compliance. Now, why would you require even such a compliance? You would require a compliance in order to reduce or minimize the risk that would come if there is a CCI summons or inquiry or investigation. Now, how do you get it? Now you reach there by ensuring that there are periodic training sessions. You reach there by ensuring that there are actions taken against non-compliant employees, because any action of employees can land the company in trouble. So let's say my sales manager has gone off to your home for a dinner, and over the dinner they discuss certain strategies. This, if gets documented, it could land my company into trouble. If it doesn't get documented, I still should have a system or a framework where I would ensure that it identifies it and takes action against it. So that is the whole idea of the framework. As I mentioned, that is not taken off in a very big way. Documentary wise, it has taken off in a manner of speaking, because there is already a lot of accounting compliances that is in place. So whenever you have an internal audit of the procedures, of the documents, of the commercial agreements, all of that is part of the competition compliance. So we can call it the competition compliance manual, or we can call it the competition law compliance. But essentially, the moment you have a review of the documents, of the procedures, of the commercial agreements, all of that will go into compliance of your competition commission. So with this comes the compliances part to an end. Now I will go into the theory part. So I had explained right in the beginning that I'll keep the theory towards the second half, primarily to ensure that all of your interest is captured in the compliances part, or your role is captured in the compliances part, and then you understand the theory. Generally, I do the reverse around. If it is where an audience is primarily of lawyers, I always go with the theory, the judgments, and then anything else that is important comes up, like the due diligence and stuff. So how did this so-called competition law come into India? So the history of competition law has been always there. It's not like it just took birth in 2007. The whole point is it came about through the industrial policy. It came about through the MRTP Act. So whole idea of the MRTP is to ensure that the monopolistic and the restrictive trade practices, or the unfair trade practice, there is a restriction on it. So all of that development evolved in competition law in 2002. Now 2002, when it came about, it essentially, and even today, it has essentially three branches. So first branch is your anti-competitive agreements of all nature. Second is the abuse of dominance, where you do not have an agreement, but you have a position of dominance in the economy, in the market, and you choose to abuse it. In such situation, also the Competition Act comes into play. Last but not the least, when the Competition Commission has an element of mergers and acquisitions. So whenever there is more than one company coming together, be it through your amalgamation or acquisition or mergers, this is one thing that they see, that does it reach to such proportions that it will have a appreciable adverse effect on the economy? Will it reach to a position of dominance because of such merger? If so, then it needs to know, it needs to identify, which is why it has taken mergers and acquisition as a permission rather than, by the way. So as I had mentioned, whenever you are having Section 6 exemptions and a merger can go through the exemption list, then the CCI is not interested. But when it cannot go through the exemption list, then the CCI is very much interested in knowing whether it will have an impact on the market. If so, whether they need to keep an eye out for it, whether they need to keep an information for it. So that is where they bring about your 210 days. So if it is something very just by the way it's grazing the trigger points, then the 210 days rule follows. If not, they will ask for the documents to ensure that there is a dominant position, or there is a anti-competitive behavior, or that it might have an appreciable adverse effect on the economy. So when we speak of anti-competitive agreements, essentially we are looking into both horizontal, that is lateral, and vertical. So manufacturer to manufacturer is called your horizontal, manufacturer to retailer, supply chains is called your vertical arrangements. Now, what is an agreement? It can be, since under law you can have both written as well as a oral agreement. Essentially, when we understand, it's an action in concert. So agreement doesn't always have to be jotted down or expressed out on paper. It can also be a tacit understanding. It can be a tacit arrangement. It can be simply action in concert. So for example, if for public transport, you would always find that people collect at one point, where the public transport would collect all of them. Call it a bus stop, call it an airport, call it a auto stand, doesn't matter what. So it's action in concert. So you know that this group of people are traveling from point A to point B, and you can identify who all are traveling. Now, just traveling in a same transport, that does not necessarily mean all of them have the same aim. But if it so happens that instead of people traveling in public transport, you have business meetings at different associations, places, or different venues, or you have absolutely same pricing for the same type of product, then it seems this action in concert is something that is not to be taken kindly. So whenever you have an agreement in between an actual or even a probable potential competitor, in order to ensure that there is no creation of monopolies or cartelization, the Competition Commission keeps a very stringent watch. And this is like the horizontal agreements, that is the worst of it all, wherein they keep a strong watch on the market if there is implicit behavior amongst the players with regard to commercialization or standardization of documents, or if there is a information exchange. Vertical arrangements or agreements, on the other hand, have an impact on the economy or at a different level, while they do increase the efficiencies, and which is why you have vertical takeovers or vertical agreements. The whole idea of it, that such integration should not entirely hijack the supply chain from the market, ensuring that there is no other competitor left. So this removal of competition in the market would at some point of time have an adverse impact on the consumers, which is why vertical agreements, though they inherently increase the efficiency of the market, are something that the CCI keeps a lookout for. So this is what horizontal agreements are, where people meet. It can be a casual meeting, it can be a formal meeting, and where they combine their strengths to do a better business for themselves. There is no harm in doing a better business for yourself, as long as it does not impact or harm your other competitors who are not participating, or the consumers who are going to be directly affected by it. So you can have these different types of horizontal. So reduction of output, like OPEC does, or cooperative behavior where everybody benefits because of such cooperative behavior. Cooperative behavior can take many forms. It can take form of dividing the market. It can take the form of dividing the business. It can take in supply chain, it can essentially be replicated in very many forms. Market division is something, again, where I own this market, so this market is mine. So this is something which essentially drives out the competition from the market because of such tacit understanding with the competitors. So similarly, similar pricing, where there is just a few 1 rupee or 2 rupee or 5 rupees difference or few paisas difference. So it's like similar prices being charged for the similar product. In such a situation, that also would be under the definition of your horizontal agreements. So when you're talking about horizontal, this is what is identified as appreciable adverse effect. So when you have price fixing, then you have your section 3. We have discussed section 3.3. When you have market distribution, like you divide a cake, you have 3.3c. When you have collusive tendering or collusive behavior, then you have 3.3d. Or when you have caps on the output in order to bump up your production, or to bump up your business, in such a situation, they would apply your 3.3b. Now, how do they prove it? This existence of agreement is very difficult to prove, which is why they take the preponderance of probability, which means circumstantial evidence of any and every nature would have not only a persuasive value, but will be of a significant value in establishing the evidence of your horizontal agreement. So once it is established, then the penalty can be up to 3 times. 3 times of what? 3 times of the profit of each year of such behavior, or it can be 10% of the entire turnover for each of the years where you had such behavior. Now, how do you define? All of us can understand a cartel when we perceive one. We can see a cartel, we can understand it, but identifying it is difficult. Internationally, OPEC is the best example of a cartel, where in between themselves they determine the pricing, they determine the output, they determine whom to sell, whom not to sell, and all those things. So essentially, that is the definition that holds true even for domestic. So whenever you have an association, a trade association, that can be the starting point or the trigger point of formation of a cartel. So a cartel is said to exist when more than one enterprise, two or more enterprises, enter into any form of implicit, tacit, explicit arrangements for fixation of prices, production, supply, market share, sales quotas, or any other bidding process. So any behavior which is cooperative in nature can be said to be cartel behavior. So cooperative behavior in between competitors is something that is not well looked up to by the CCI. So these are the conditions which are conducive to cartelization. So you have, how do you, what is the incentive of getting into a cartelization? The incentives are when there are very high entry and there are very high exit barriers, which means to enter into the market, it's prohibitive. You require deep pockets, or exiting from the market would render losses. Again, that takes me back to your mobile operators, Vodafone versus Jio. So that is something that might lead to having a compromise or an agreement in between the providers, where you have a very, very high dependence of consumers on the product. In such a sense, also, it provides a very strong incentive for having cartelization, where the production is of a similar nature or the production cost is of a similar nature. In such situations also you can have cartelization or incentive to have cartelization. Then comes the concentration of few competitors. When you have just two players or three players in the market, the whole idea of it is, okay, let's divide and conquer. We divide the markets, we divide the prices, we divide the output. So there is again a huge incentive for cartelization. So when we speak of tacit collusion, when we speak of tacit coordination, in such a situation, this is what we understand: monopoly, oligopoly, monopolistic behavior, perfect competition. Perfect competition is like the utopian idea that every regulator, competition regulator, has across the globe. So this is what we say that, okay, because of interdependence, you will invariably either have a monopoly where one company rules all, or an oligopoly where you have more than two or three, just very few, because of the high entry and exit barriers, or because of standardization, or because of pricing strategies, or because of supply strategies. You will have just few handful companies who behave in a manner that is a detriment to the market. Then comes your this invariably results in your either a competition that is affected or a perfect competition. So whenever there is a perfect competition, your CCI will not intervene. But whenever there is a monopolistic competition, in such a situation, CCI will always have a intervention. How does it identify? It identifies by the interaction that the players have in between themselves. So you'll find that whenever there is strategic interaction, that is where you will have your impact on the market. So I was talking to you about the cement manufacturers. In 2012, the Builders Association of India took the cement manufacturers, and the CCI literally brought its entire weight on this case, and the coordinated behavior of the cement manufacturers was brought to the forefront. So not only where it was available on the details of actual production, their capacities, price parallelism, coordinated behavior, all of it was easily proved because of the various evidences that these business houses had. So opposite parties or competitors would meet frequently, and they would, in these meetings, they would discuss their marketing strategies, business strategies. they would collect all the details, and because of this, there was a nexus in the pricing of the products, of course, and that is where the Builders Association had an opposition to. So this is what happened in the case of your Cement Manufacturers Association. So they don't take an offense when we write it as CMA. I know it is not affecting you, but still we could have your CMAs in here as well. Apologies to them, but that's the way that the abbreviation is generally used. This is the leniency or the lesser penalty program that I have discussed in the past. So the whole idea of giving a lesser penalty is to ensure that there is some incentive, there is some protection given to the first mover who decides to break away from the group and come forward with the information and the details therein. So all of this I've already discussed, so I'm not going to discuss it. This is the procedure of availing your lesser penalty. So for lesser penalty, there has to be an application. Once the application is put up with all the evidences and everything, then within 5 working days, the Competition Commission will have to take a stand or a consideration. Once it is marked as a priority in such a situation, it will be conveyed to the applicant. Once it is conveyed, this priority status is conveyed to the applicant, they will become eligible for the lesser penalty. But a mere acknowledgement that they've received is not an entitlement. It is only when a clear indication of priority status is provided for, only then will the Competition Commission enable a lesser penalty for them. At the same time, a date time will be provided, the evidences will be evaluated, and they will not be brought into the punitive framework, but they will be kept apart. So once there is one person in, you cannot have more than one person theoretically, until unless they come up with different evidence, they come up with different other elements, then they are entertained, but not otherwise. So these are the provisions that I've already discussed in the past. So when it comes in how much of the evidence they have, the quality of the evidence they have, the circumstances of the case, that will always have a strong bearing on how much of reduction that they give. So 100% when it is a first mover and makes a vital disclosure. Again, 100% if without such disclosure, the Competition Commission had little or no evidence of value, then again there is a benefit of penalty provided. 50 to 30% when there is more than one applicant but different evidences that is provided by them, there is value addition to the evidences provided, there is corroboration of the collusive behavior in such situation. The second and the third applicants can get something in between 50% to 30% waiver in your lesser penalty. So these are some of the cases that, so in this dry cell batteries case versus Everready, Panasonic, because it was the first mover, it got 100% waiver. So it first approached the commission when they were not even looking into it. They provided the evidence with regard to the market structure, the information exchanges, locations, email accounts, your KMPs. They cooperated and conducted, they enabled the Director General to conduct your search and seizure operations. So they could avail 100% of the lesser penalty. So they were given absolutely no penalty whatsoever. Everready Industry was the second in row to make such disclosures. They got 30% because they came just 3 days after the search and seizure. So Panasonic was before the search and seizure. They enabled or they made it conducive for the DG to have the search and seizure. They gave out locations, they gave out email accounts, they gave out the names of people. So nevertheless, when Everready came forward, it was also providing corroborative evidences, so it got 30%. So Indo National got 20% because they came in a week of 3-week delay, and The reason that they were given even after 3-week delay or 20% was because they provided absolute cooperation in the investigation process, which led to the case being finalized. Now, in this case, in this 2015 case, in this Nagarik Chetna Manch case, again, the same thing was seen. You had more than one, your Mahalakshmi Green and then your Sanjay agencies, where you had 50, 40, and 25, primarily because of the different stages that they entered and the cooperation that they extended to the Competition Commission. This is the Z case, that is SL Shyam Communications. So in such a situation, again, because the Globecast made vital disclosures and was cooperative throughout the investigation, they got a waiver of 100% on the penalty, whereas SL Shyam got a waiver of 30% because they had already, some of the evidences were already collected, and in addition to it, they cooperated with the ongoing investigation, and they had cooperated with the investigation of the DG. Now let's come to vertical agreements. I hope I have time. Yes, I do. Now, what are these vertical agreements? Essentially, again, as I said, while they do increase the efficiency of the market, they also have impact on the competition, primarily because of the nature of such agreements, wherein they come down very, very heavily on the market. So this identification of vertical agreements is much, much easier than your horizontal, and they do have a beneficial impact as well. So what is seen is consumer interest versus commercial interest of the company. So once the commercial interest of the consumers is established that it has not been impacted, generally vertical agreements are left on their own, they're left alone. But where it is determined that yes, vertical agreements are not conducive to the consumer interest, then identification of your appreciable adverse impact is seen. So the section 19 comes in, and the interpretation of section 19 comes up and looks into the negative factors of the vertical agreements. So these are the different types of vertical agreements that we understand under the competition law. It can be at different levels of production, distribution, supply chain. Essentially, you have like 5 types of vertical agreements that is identified and acknowledged by the Competition Commission. That is your tie-in arrangements, exclusive supply arrangements, exclusive distribution agreements, refusals, and resale price maintenance. So these are the 5 elements that is seen as identification of vertical agreements. Again, here I'm going to repeat it, but Competition Commission will enter into it very, very reluctantly. It will enter only and only if there's a clear evidence of consumer interest getting affected. So more often than not, vertical agreements are essentially left on their own, whereas horizontal agreements, because of its very inherent disruption that it brings about, collusive behavior that it brings about, which is why it does not, the Competition Commission comes down very, very heavily on it. So, as I have been saying, vertical agreements are incentivizing. They increase the efficiency of the market. Now, in this slide, what I have done is I have essentially tried to put down where a vertical agreement can be an issue. So let's say, for example, in between 2 manufacturers, same dealer, you can have a vertical agreement. Intra-brand, where the manufacturer and dealer have joint profits. So as long as the market is without barriers and the dealer can take on other competitors as well for the same sale of the product, then there is no issues. But when there is an exclusive, In such a situation where you have exclusive distribution agreement, where you have a minimum purchase, or when you have an exclusive supply agreements, in such situation, the analysis on the impact of the market becomes critical. So identifying what is the relevant market becomes the first step in dealing with this problem. What is a relevant market? A relevant market is the market where such vertical agreement would have an adverse effect on the consumers. So this relevant market can be a geographical market, it can be any other form of market, as long as it does not, the market does not lead to creation of barriers, it is left on its own. It's only when it creates barriers, that is when the competition comes into this. Now, the best example that I have on this is your Sonam Sharma case. I don't know if any of you are familiar with it. This is otherwise known as the Apple's case. So essentially, Apple had very clear uh, directions with regard to its supply chain, and it was very clear that they would have, I mean, it is not something that they have not done in markets abroad. They would tie up with the the service providers. So Vodafone would give for a plan with the Apple phone. They were very briefly in the market, and when there was, at that point of time, Sonam Sharma went into this CCI. So a particular phone would be available with the services, with the exclusive service contracts, be it with Vodafone or Airtel. And just because iPhones were not available without such plans, this came into the ambit of CCI. So if you had the freedom of purchasing iPhones without the plans, then it would not have been an issue. And only because they had service agreements which worked in different countries, they said that, okay, let's have tied in service agreements with the service providers, be it your Vodafone and Airtel. So in such situation, CCI very clearly said that you cannot sell a phone that is compulsorily locked. That means you cannot sell a phone which the consumer will have to essentially use only the Vodafone services or the Airtel services. You have to unlock the phone so that they can change the service provider. Now, this would be very counterintuitive for the companies. So what CCI did was it brought about the argument that Apple is a dominant player. It was not, but it brought about the argument that it was a dominant player in the smartphone market in India. It might have been a dominant player in markets outside India, but it definitely was not here. And then it decided to combine the market of Vodafone and Airtel, which should not have been, because Vodafone had its own separate market, Airtel had its own separate market. There are areas where Vodafone is better, but there are areas where Airtel is better, and the customer did have a choice of going either the Vodafone way or the Airtel way. It just did not have the choice of shifting midway without having paid the full amount. So they brought about this, they added the market, and they said the combined dominance is more than the 52% of the entire market. So they could drag in the element of abuse of the position, which was not there, honestly speaking. Then they looked into the exclusive distribution agreement. And they said that because of the exclusive distribution agreement, you had a limitation on how much can be supplied. And because of this, the order came out that, okay, there exists a prima facie case, and hence let there be an investigation. So the Director General does the investigation, and it comes out with a set of questions: whether there was an exclusive agreement, yes; whether there was an appreciable adverse effect, yes; did it affect the other business cellular providers, no; did it limit iPhone supply, yes; was there a tie-in agreement, yes; did that cause a double AEC, no. So all these questions were answered by the DG itself, and ultimately they said, well, go to try, because this does not fall under CCI but under try. So once it went to try, the try tribunal then said that, okay, you have to unlock the phones and sell. So if you want to sell the phone, you can sell the phone. If you want to sell the services, you can sell the services, but you'll have to sell, you cannot sell locked phones in India. So essentially, by the time all of this concluded, it was redundant because your Apple realized very quickly that this market is not fit for such tight-end agreements, and because of which the agreement which they had essentially expired in the meanwhile. It was just a one-year agreement. And since they were a minuscule player, it's an exclusive player, they could not even prove that there was an appreciable adverse effect on the market. So Apple can sell its iPhones, but not Vodafone, not Airtel. Vodafone and Airtel can sell, but they'll have to unlock so that the switching of it is provided. So this collective dominance, a concept that was brought about, was essentially led to a lot of futile waste of time, money, and resources. So this was the decision that was brought about. So essentially, I've discussed this decision while I was going through the case details with all of you. So they had to conclude that there was no breach of your Section 3. Of course, then CCI has to agree with the Directorate General, and they said that, okay, fine, 52% is not a major dominance. It is just a joint dominance. So they cannot be considered at horizontal, nor do they have any anti-competitive behavior. And they came out with something really, really interesting observations about Apple wanting to test the waters of the Indian market, and hence it had this tied up framework. The consumers had a choice. They could go in for the iPhones, or they could go in for other available phones. So their observations were fairly redundant, because this service of tying up with the service providers is a very, very prevalent notion that your Apple enters into various markets, and it just deemed that maybe here it too can do the same, but it never calculated the impact of your TRI and CCI combined. But what that good came out of it, the only good that came out of it was an academic exercise, in the sense that we could identify the conditions that could be said that these are the conditions that is required to identify what an anti-competitive tie-in arrangement is. So these four conditions, if they are met, then you can say that yes, there is a tie-in arrangement. So what are these four conditions? First condition is where the purchase of any commodity is conditional on purchase of another commodity. So Airtel or Vodafone service provider bundled with the Apple phone. Now seller must have sufficient market power to able to force the purchaser to buy the tied product. Now nobody was forcing anybody, but they said that, okay, fine, if they're compelled to buy. So this compelled to buy is a very, very subjective one, but still it was put up as condition 2. And then they said that if the effect on the market, if there is a substantial effect on the market again, then it will be seen as your anti-competitive, but not otherwise. Collective dominance has not been defined in the Act, though it was taken up by the DG, it was taken up by the CCI. They said that, well, since it's not under the purview of Act, it's outside our purview too. So essentially, these were the four conditions that came out as identification marks of what an anti-competitive behavior or a tie-in arrangement is. So that is the thing that I've put in the next few slides. And these are the remedies that is provided for. What are they? That you have a cease and desist order, you have a modification of behavior, that is your affirmative action, then you have imposition of penalties, and then you have the collection of recovery of your compensation, of your penalties, and any other punishments that they would give. For compensation, the section 53 enclad sure. Okay, that so these are the remedies that was brought about, And with that, I come to the close
Yes,
of
ma'am.
the session. Maybe we can take some questions from here on
Questions, if
forward.
any, yeah. Yes, ma'am. Yes, ma'am. Yes, ma'am. And if there is any question, audience, they have option to unmute and speak. And I have
Okay.
unmuted everyone. So questions, if any, they can unmute. We'll wait for 1 or 2 minutes, ma'am. There's no
Okay.
question in
No
chat
problem.
box actually. Members, if there's any question, you can unmute yourself and hello.
Yes. Doesn't look like there are any questions.
Actually, there are questions. Actually, if there's any, if it has come through our mailbox or something, we'll share it to you. Ma'am. Time permits, you can respond for the same. And I'll check with Rekha ma'am if she is there. She's held up with the meeting, it seems so. So I will check with her. Not
Right.
so, we'll close the session now. Rekha ma'am, are you there? Yes, ma'am. There are not much questions, ma'am, so we can close the session. Yep, ma'am has come. You need to
Do you
unmute
have
yourself.
any questions?
Yes, ma'am. No, there's no.
Am I audible, sir?
Yes, audible, ma'am. Audible. I have a question.
Okay. So do we have to wait for the questions or shall we close the session?
No, we have been meeting for 1 or 2 minutes. We have unmuted audience also. Yes, please, sir. Please.
Yeah. So my question is, many of the some of the social media platforms have a very huge share of that particular platform, and they also deny access to other platforms. So, for example, one is not interoperable with the other. Can this at some stage attract Competition Act, and they may be asked to be interoperable? For example, I'm just giving a, so they can say that messages from Telegram should be allowed to come to WhatsApp, or Coup and Twitter should be able to interoperate and share messages or whatever.
Well, two things that you have to understand. The basic essential ingredient of competition is, are there other competitors? Even if we take something as simple as portability be it of insurance, of service providers, telecom service providers, or even of your gas supply, you will not be able to have, let's say, for example, HP and Indian. You cannot have an Indian connection and then pick up HP cylinder and vice versa. But if you wanted, you can port it out. You can change it to HP, and then you from HP to Indian to HP as many times as you want. Similarly, with the telecom people as well, you can keep changing, but you cannot force them to provide, like, plans of Vodafone to be applicable to plans of BSNL, or BSNL plans to be applicable to Airtel. So anti-competitive behavior is where there is an option left to the customer or consumer or not. First thing. Two, does it suffocate out competition? Three, it does not look into interfaces, interoperability, which is why CCI threw the Sonam case to try. So no, sir, I don't think that will apply to a competition commission.
Okay, just one quick remark on that. The networking effect of these platforms does suffocate our competition.
The networking of?
The networking effect, meaning the more users a particular platform has, the more users it will attract, right? People stop using the other.
Correct.
So it does suffocate competition.
Yeah, which is what makes them valuable or invaluable to certain companies. I mean, WhatsApp got acquired primarily because of the intuitive usability of it. So you see, they do not suffocate behavior. One company can always make itself the best in the market. What it cannot do is it cannot talk to its competitors and ensure that without even being the best, it remains on top of the market. So no, sir, again I'll have to say no to your point.
Okay.
Thank you, sir.
Ishwar, is there any question from you, sir?
Rick, I think we can safely close. I don't think there'll be.
Yes, yes, ma'am. Over to you, ma'am, for vote of thanks. Rekha, ma'am.
Okay, thank you, sir. Ma'am, I think that you were able to convince the person who has asked the question now. So I think thank you very much on behalf of SIRC for taking up this session. Amidst your busy schedule, I'm sure you'll be having so many other engagements. Thank you so much for sparing time with us and taking us through all the nuances of Competition Act, especially with respect to the clause 3, the anti-competitive agreements, and even patiently answering the questions that is met out by the members. Thank you so much, and we would like to have you for a physical session at SIRC also. Thank you so much.
I look forward to it. Thank you so much, Rekha. Thank you so much. How do I close this session, or would you close this session for me?
Thank you.
Please?
We'll end that.
Thank you.